Welcome back to the Friday Five for March 10th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to look back on the week and look at 5 questions that came up that may be of interest to you as well. Here in Minnesota, we're trudging along towards a top 10 snowiest winter. We should get some more snow this weekend, so it's good to stay inside, warm up with a cup of coffee, and maybe go through some of these questions. Question number 1. What states still recognize common law marriage? So this came up in the context of a consultation with a New York client who was with his partner for about 15 years in New York. Unfortunately, the partner died, but the partner and the client never actually got married. They were never domestic partners. They just lived together. And so the question, and it's a question I get a lot, is were we in a common law marriage? And the fact is that common law marriage is actually not recognized in most states in this country. However, if you're wondering where is common law actually recognized, those states are Colorado, Iowa, Kansas, Montana, New Hampshire, Oklahoma, Rhode Island, South Carolina, Texas, Utah, and the District of Columbia. So I don't practice law in any of those states, so I don't normally run into the common law marriage claims and what that can mean for your estate plan. However, if you're in one of those states and you have a question about common law marriage, you should definitely reach out to a local attorney who can help guide you to the right answer. Question number 2, do I need witnesses for my will signing? This is a very common question that comes up with clients as we're setting up the final will signing ceremony for them. And here in Minnesota, as well as in New York, New Jersey, and Connecticut, where I practice law, we want to make sure that we have 2 witnesses to every will signing. Some people try to get away with doing 1. Some people can actually try to use family members who are in the will, who are not proper witnesses to the will. So what we want to do is make sure that we have the correct number of witnesses and that they're qualified witnesses. Because the answer is you probably do need witnesses to your will. And it's when you don't have witnesses and then somebody dies and we have questions about the will that these kind of issues arise. This is one of those little pebbles that comes up when you use an online drafting site who just gives you the form, you print it out, and you go sign it in the way that you think you should be doing it. And you may be missing an important formality that may make that will invalid and leave behind a lot of headaches for your family. Question number 3. If I amend my trust, do I also have to amend my will? So this is going to be one of those classic lawyer answers of it all depends. So just because you're going to amend your trust does not mean that you must amend your will. But it's going to really determine, what's really going to determine this question is what are you amending in the trust and whether or not there's something in the will that needs to be amended as well. So this question actually came up in the context of a client that had a will and a trust from the late 1990s. So in this situation, we definitely needed to update the trust. However, the will would have been okay if we didn't amend it. However, in looking at the changes that the client wanted to make, we looked at the will a little closer, and there were some provisions in that will that wanted to be updated as well. So if you're dealing with an older estate plan document, maybe from 15 or 20 years ago, or even more, if you're going to be amending one, you may want to look to see whether or not you want to amend the other. You don't have to necessarily, but you want to make sure that if you're amending one, that you're making the right changes in both if needed. Question number 4, can my trust own my LLC? So this came up in the context of a business owner. She's got a great business growing on the East Coast, and she also has a trust that she uses for estate planning. And she'd been reading some things online. I think she'd seen a couple of my videos, and she wanted to know whether or not her trust could have an ownership interest in her LLC. And the simple answer to this is yes, it can. And what we want to do is look at the state where your LLC is formed and see what those provisions are regarding ownership. We want to, in this case, she wants to use the trust to be able to pass on her LLC interests through the trust to somebody else. And in the state where she was, in New York, we were able to put together a plan for that so that the trust could own the LLC. So in a simple answer, yes, it can, but you want to make sure you're working with a professional so that if you're going to set up this kind of structure, you're setting it up correctly. And question number 5, can my LLC own multiple assets? From the same consultation out in New York, the client has this business that's growing and she wanted to know if she could put other assets into the LLC. The reason was we looked at things like rental property LLCs, and when you have a rental property you're putting into an LLC, my recommendation is normally that we put 1 property per LLC. So if we have 5 properties, we want to set up 5 LLCs. We may set up another ownership interest above that would then own the 5 LLCs, but we want to make sure that we put one property in one LLC. However, you can put things together in an LLC. So going back to our real estate example, you could also group those 5 properties into one LLC, or you could group 2 into one LLC and 3 into the other. Let's say 2 of them are in Springfield and the other 3 are in a different town. You can group each of them and have your Springfield Properties LLC, then your other town LLC. The downside of doing that, of course, is that if there's a lawsuit against the LLC, the assets of all 3 properties would be available. And so in this case, what we were looking at for the client is, can the LLC own multiple assets? Yes, it can, but the question is, should it? When we're looking at liability protection, do we want to make sure that those assets from those other assets are not available if there's a lawsuit regarding the underlying LLC? So those are our 5 questions from the week. As I said, we've been getting snow out here. There's more coming this weekend. We're pushing into the top 10 of all time for Minnesota. And if we get one more snowstorm, we might end up in the top 5. So there's a link in the description if you'd like to ask questions for future episodes. If you found this helpful, I'd love if you hit the like button below, give it a thumbs up. And if you want to subscribe, you can go to YouTube and subscribe to all future episodes. Wherever you are, whether you have snow or not, I hope you have a wonderful weekend, and I will see you next week.